Is it easy to update my estate planning documents? I'm Sarah Siedentopf. I'm an estate planning attorney in Atlanta, Georgia. And of course, this is a question I get quite regularly. Is it easy to update? How do we update? What happens when I need to make changes? Of course, it depends on the document because different documents have different rules for what makes them valid. The worst, if you will, is the last will and testament, which here in Georgia requires 2 witnesses and preferably, oh my goodness, please, a notary. The notary is not required to make the will valid, but if you don't have the notary, we have to chase down witnesses after you've passed away, and especially if you are planning to live for a good long time, that could be a problem. So redoing a will or doing a codicil to a will still requires that 2 witnesses and a notary. Trusts, we really need a notary. We strongly prefer at least 1 witness. If you're doing a trust update with a will update, we're going to have 2 witnesses. So the biggest thing is that all of these updates require the same formalities that the original did. So is it easy? Yes, no, maybe. You do have to re-sign it with the original formalities and have some extra people brought in. If you come into the office, we take care of all that. Sometimes it's as easy as, hey, I want to change XYZ, and I can, do a draft changing it, send it over, you review it, we schedule a signing. So it can be fairly easy. Now, some things are easier than others in the sense that the Advance Directive for Healthcare, which is, Georgia's medical power of attorney, only requires 2 witnesses. Those witnesses can basically be anybody. They can be your neighbors, your coworkers, your friends, whoever you want. So, we don't have to track down a notary. It is a form that you can download online and write in your changes. A lot of times people reach out and they say, hey, such and such happened. Do I need to make a change? And, one of the big ones, of course, being, we've had another child. Usually the answer is, we said in your documents that, XYZ was split between your children, so that covers, the child that you had then and the children you will have in the future, so we're solid. And, I also get a lot of questions about, I've moved, or, my power of attorney has moved, and generally speaking, my only issue is, if you've moved, and you have a trust, is your new house in the trust? So we might need to do a deed putting it into the trust, but we don't have to go through and update every single document because, your phone number is probably the same. Your email is probably the same. We can track you down. If you change all of your information, your phone number, your email address, and your physical address, we probably should do some updates. And certainly if we have enough changes running around at once, it can make sense to update. Depending on, what we're doing, sometimes we just start from scratch and you say, do you need to see my old will? It's like, unless there's a specific clause in there that you want me to replicate exactly, no, I don't need to see your old will. Please just make sure after we create the new one that you destroy it. On the other hand, if we are, amending a trust, yes, I do need to see that trust. If you've got questions, I'd love to hear from you, and please like and subscribe.